Hello, my name is Ken Burke, and I'm your elected Clerk of the Circuit Court and Comptroller for Pinellas County. We have created a series of videos to assist you with completing the forms or packets that you will submit to either initiate your case or address issues that have arisen in a pending case. To ensure that your documents are processed quickly and efficiently, it is important that the documents are completed fully and properly. This short video will take you through the forms or packets as well as answer some of the most frequently asked questions. At any time, please feel free to pause the video and take a moment to fill out the applicable section. Once you have completed the form or packet, please refer to our website or contact our office for instructions on how and where to submit these documents. Should you have any additional questions regarding a family law, small claims, or landlord-tenant case, affordable legal services are offered through the Clerk's Self-Help Center. Please visit our website at www.mypinellasclerk.org for additional information. Thank you.
The petition for support unconnected with dissolution of marriage is used if a dissolution of marriage has not been filed and you are requesting alimony or child support. If you have already filed a dissolution of marriage case, you will need to seek relief through that action. This petition does not address the issues of property or debts. It only deals with alimony or child support. The petition for support unconnected with dissolution of marriage with minor children is used when you want the court to enter a support order if your spouse has the ability to contribute to you and your minor child, but has failed to do so. You can only use this form if a dissolution of marriage has not been filed, and based upon the time-sharing schedule, you are entitled to support. If a petition for dissolution of marriage has been filed, you should file a motion for temporary support and time-sharing within that case. This petition cannot address the issues of property, debts, or parental responsibility and time-sharing with the child. It only deals with alimony and child support. While a clerk of court cannot provide legal advice, the Self-Help Center has attorneys on hand for a reduced rate to assist with any questions for parties representing themselves. Go to mypinellasclerk.org to find out more information on assistance for self-representation. First, let's go over the information that is required on pleadings filed. The header must include the location of your case by entering the judicial circuit and county. Pinellas County is located in the 6th Judicial Circuit. The case style states who is the petitioner and who is the respondent in a lawsuit. The person who originally asks for legal action is called the petitioner and remains the petitioner throughout the case. The person against whom the original legal action is being requested is called the respondent, because he or she is expected to respond to the petition. Your case number is a unique number used to identify your case and is assigned in sequential order in the court it is filed in. This will be provided to you when you file your case. A case number may be referred to as a reference number, UCN number, or case number. Always remember to sign and date any filing where a signature is required. Some forms, such as affidavits, are notarized documents. Wait to sign these documents until you are in the presence of a notary or deputy clerk. Please bring photo ID with you. When you file a document with the court, you must also provide a copy for the other party. Be sure to put in the correct information of service on each form. If someone other than an attorney in good standing with the Florida Bar Association helped you fill out a form in this packet, enter their name and contact information on the forms that request it. Read all forms and complete the required fields. Please make sure to provide accurate information and print clearly. All questions need to be answered. This form must be used when anyone who is not a lawyer in good standing with the Florida Bar helps you complete any Florida family law form. Attorneys who are licensed to practice in other states but not Florida, or who have been disbarred or suspended from the practice of law in Florida, are non-lawyers for the purposes of the Florida family law forms and instructions. The non-lawyer must complete this form and must be signed by both you and the person assisting you before completing any family law form. Florida Rule of Judicial Administration 2.545 Section D requires the petitioner in a family law case to file with the court a notice of related cases, if any. A case is considered related if it involved the same parties, children, or issues and is still pending when the family law case is filed. A case can also be related if it affects the court's jurisdiction, or an order in the new case will affect an order on the same issues in a different case. Always read through the entire motion before filling in information in the fields provided. Check the box that applies to your case. If there are no related cases, check the appropriate box and proceed to sign and date the notice. If there are cases related to your action, list the case information in the provided fields. Check the box that corresponds with the related case type. If none of the options apply, use the other box to enter the case type. Check the box as to where your case was filed. Fill in the state where the case was filed if it was not in Florida. Fill in the name of the court and the last order or judgment filed in the case. For example, if your case is in Pinellas County, the name of the court would be the 6th Circuit Court, Pinellas County, Florida. Next, check the boxes that apply to the relationship between the two cases. Include further detail of the relationship below. If you have more than one related case, list each one separately in the spaces provided. If you would like the related cases to be coordinated between the two courts, check the appropriate box and list the case number in the space provided. Check the box that best fits your situation. If you are unsure which one to check, you may need to consult with an attorney. Remember to sign and date the completed form. Next, you will fill out the Family Law Cover Sheet. This document is used for reporting judicial information pursuant to the Florida statutes. Place a check beside the proceeding you are initiating. If you are simultaneously filing more than one type of proceeding against the same opposing party, such as a modification and an enforcement proceeding, complete a separate cover sheet for each action being filed. If you are reopening a case, choose one of the three options that correspond with the motion or petition you are filing. Check the box that most closely matches the action you are filing. If you are reopening the case for further action, this section can be left blank. Check the box that correlates to your knowledge of related cases. The petition for support unconnected with dissolution of marriage with and without minor children are very similar. When using the petition without children, you will not be asked any questions regarding minor children. Begin by entering your full legal name in the provided space. Complete the questions to the best of your ability. Take note that additional forms are required. The additional forms can be found within the packet. Answer the following questions. Provide the information regarding your request for relief. Answer the following questions regarding your request for child support. Provide any additional relief you are seeking. This section summarized what you are asking the court to include in your order. Indicate any and all that apply. This form must be completed by each party. The information within the form will remain confidential, per Florida Rules of Judicial Administration 2.420. Complete the statement with your individual information. Select the option that applies. If there are minor children, enter their full names, date of birth, and their socials. Use this form in any case involving parental responsibility for, custody of, or time sharing or visitation with any minor child. This affidavit is required even if the parental responsibility for, custody of, or time sharing or visitation with the minor child is not in dispute. Begin by entering your full name and the number of children subject to this proceeding. Read through the form and fill in the information requested about the minor children. Include every location the child has lived in the last 5 years. Complete the remaining sections for each child related to your case. If there are any other proceedings regarding the custody, visitation, child support, or care of the minor child or children in this or any other state that you have knowledge of or have been a party to, check the appropriate box for your situation and enter the requested information if applicable. This form is not required if you are filing the petition for support unconnected with dissolution of marriage with minor children. If your family law case requires a financial affidavit, select from the two forms provided in your packet that best fit your financial situation. Enter your current employment information. If you are unemployed at the time of filing your financial affidavit, leave these fields blank and check the box below. You will need to include an attachment to your affidavit stating efforts to find employment. In this section, you will list your gross monthly income. This is any income you receive before taxes or other monthly deductions. If you have any income not listed, provide more information on a separate piece of paper and attach it to your affidavit. Here you will include any monthly deductions to your income. Follow the instructions on the form to total your present net monthly income. List your monthly expenses. Use the blank fields provided to include any expenses not listed. If you must estimate an expense, be sure to write estimate next to that line. Total all your monthly expenses on line 28. Follow the instructions on the form to enter any surplus or deficit you have after subtracting your expenses from your net income. List your assets and liabilities. Use the non-marital column only if you believe an item is non-marital, meaning it belongs to only one of you and should not be divided. You should indicate to whom you believe the item or debt belongs. Some examples you might check non-marital for are property or debt that was obtained before the marriage. Last, Florida's Family Law Rules of Procedure require that a Child Support Guidelines worksheet must be filed in your case if there are minor children at or prior to a hearing to establish or modify child support. Check the appropriate box for your situation. Mandatory disclosure requires each party to provide the other party with certain financial information and documents. Each party must provide the other party with the documents listed in Section 2 of this form if the relief being sought is permanent, regardless of whether it is an initial or supplemental proceeding. The documents and financial information should be provided directly to the other party and not filed in the case, except for the financial affidavit and child support guidelines worksheet if there are minor children. This certificate tells the court that you have complied with the mandatory disclosure to the other party. Enter the date the documents were served to the other party and check the appropriate boxes for the information you have provided. Enter the date of service and check the boxes for the information you are providing to the other party. You must provide copies of any documents listed in this section to the other party. Disclosure may be able to be waived, with the exception of the financial affidavit, which is required. Refer to Rule 12.285 in the Florida Rule of Family Law Procedure for further clarification. Waiving mandatory disclosure does not have to include all disclosure items. Check the boxes of the documents you and the other party wish to waive. This form must be signed by both parties before filing it with the court. While all documents filed in a case must be served to the other party, certain documents are required by law to be served by personal service. Personal service means that a summons, this form, and a copy of the forms you are filing with the court that must be personally served and delivered by a deputy sheriff or private process server. Personal service is required for all petitions, including petitions for modification. You cannot serve these papers on the other party yourself, or by mail, or hand delivery. You will need to locate a private process server if your petition does not qualify to be served by the sheriff. The Pinellas County Sheriff has a list of approved process servers. See their website, pcsoweb.com, for more information. Review the instructions in your packet carefully, as it contains further information of serving the other party. Enter the information requested. Be sure that the addresses are correct, as an incorrect address may result in non-service of your petition, and may cause you to incur additional costs and delay your case. The clerk will review your summons and sign it for issuance if all requirements are met. If your summons is being served by the Pinellas County Sheriff, the clerk will forward your summons and any documents to the sheriff for service. If you are serving the other party through a private process server, the summons will be returned to you and you must make arrangements with the process server. You should use this form to give the Sheriff's Department or private process server instructions for serving the other party in your case, with the summons and other papers to be served. Begin by entering the information of who will be serving the summons. Enter the information of the party to be served. Under special instructions, you can include such as the best times to find a person at a specific location that will assist with having your summons served. A non-military affidavit is filed when the court must know the military status of a defendant. Active service members are granted certain protections under the Service Members Civil Relief Act. Read through the form and check the box that correlates to your knowledge of the other party's military status. If you have any supporting documentation, be sure to file it with your affidavit. If the other party has failed to respond within 20 days of the date of service, you may need to file a motion for default. Generally, a default allows you to obtain an earlier final hearing to finish your case. Once the default is signed by the clerk, you can request a trial or final hearing in your case. Fill in the case information. The clerk will review your motion upon filing and enter a default against the other party if all requirements are met. You should complete this worksheet if child support is being requested in your case. If you know the income of the other party, this worksheet should accompany your financial affidavit. If you do not know the other party's income, this form must be completed after the other party files his or her financial affidavit and serves a copy to you. In your packet, there is a Child Support Guidelines chart. Use this chart as you go through the worksheet. Read the instructions for each line carefully. If a box is blocked out, you are not required to enter any information there. If you or the other parent is requesting the court to award a child support amount that is more or less than the Child Support Guidelines, you must complete and file Motion to Deviate from Child Support Guidelines. Check the box to indicate if you will request to deviate from the guidelines. This form is not required if you are filing the petition for support unconnected with dissolution of marriage with minor children. You should ask the family law staff if you need to bring one of these forms with you to the hearing or trial. If so, you should type or print the heading, including the circuit, county, case number, division, and the parties' names, and leave the rest blank for the judge to complete at your hearing or trial. Anytime you have a set hearing before a judge, you must send notice of the hearing to the other party. If your hearing is in front of a general magistrate or a child support hearing office, you must use the appropriate notice of hearing. Both forms can be found on the following websites: mypinellasclerk.org, flcourts.org, or jud6.org. To set a hearing date and time, you will usually have to make a good faith effort to coordinate a mutually convenient date and time for you, the other parties in the case, and the judge, except in certain emergency situations. Before you complete this form, you should contact the family law staff or judicial assistant for information regarding the proper procedure to follow. Enter the other party's name. Enter the hearing information provided to you, including date, time, and courthouse location. Include all issues to be heard. Read through the information at the bottom of the motion and order, which provides information should you need an accommodation to attend the non-jury trial. This should be done at least 7 days before your scheduled court appearance. This form is filed by the petitioner or respondent for the use of the clerk of the court for the purpose of reporting judicial workload data under Section 25.075 Florida statutes. When your case is completed, the petitioner or respondent must complete this form and file it with the clerk. Check the appropriate box if your case is dismissed before or after a hearing or trial takes place. Additionally, check the box indicating if you or the other party agreed to a settlement, either privately or through the use of mediation. A disposition or judgment was received because one of the parties was defaulted. A judgment or final order was received and no party was defaulted. If your case went to trial and you received a judgment or final order as a result. Before a judge, or in certain instances, a general master or hearing officer, can hear your case, you must first put in writing what you are asking the court to do and why. Usually this is done in the form of a motion. Enter your name and the action or issue you want addressed by the court. In this section, you explain why you think you should get what you're asking for. Be sure to include any relevant information. Once you have filled out the motion, you must file the original with the clerk of court and mail a copy to the other party in your case. If the other party has an attorney, you should mail a copy to the attorney instead. You must schedule your motion for a hearing before the assigned judge or a general master hearing officer. If you have any questions about filing your case with the Pinellas County Clerk's Office, please contact us at 727-464-7000 or make an appointment to speak with an attorney at any of our 3 self-help centers.